I want to welcome everyone for our Constitution Day lecture, which is actually happening on Constitution Day. And our speaker, Louis Michael Seidman, I'm sure is going to give us a very provocative lecture about constitutional theory and the Constitution itself. Let me just give you a little bit about his background. An undergraduate at the University of Chicago, went to Harvard Law School, clerked on the D.C. Circuit, then clerked for U.S. Supreme Court Justice Thurgood Marshall, and soon after a couple of years in the Public Defender Service in D.C., joined the law faculty at Georgetown, where he's taught largely in criminal justice, constitutional law, written a number of books, including he's the co-author of one of the leading case books in constitutional law, and among the monographs that he's published, the most recent is his book on constitutional disobedience, which has gotten a lot of attention, not just in law schools, but even in the press. So I'm very proud to have him here. Let me turn it over to him, Mike Seidman.
Well, thank you, Dean Simpson, and thank you folks for coming, and thank you for inviting me to this beautiful law school. What a wonderful place. It has not escaped my attention that an invitation to me on Constitution Day is somewhat, shall we say, unorthodox, and I think it just speaks volumes of the open-mindedness and commitment to free debate at Mercer Law School, and that is the mark of great educational institutions. So I think it just speaks very, very well of you. The thesis that I'm going to defend today can be summarized in a single sentence, and the sentence is, we should give up on the idea that we have an obligation to obey the Constitution of the United States. Now, I have to start by saying there's almost nobody who agrees with this thesis. In an age of partisan meltdown, liberals and conservatives, Republicans and Democrats, blue state and red state, progressives and Tea Partiers, the Federalist Society and the American Constitutional Society agree about almost nothing, but they stand united on one thing. The thesis I want to defend is not just wrong, but idiotic, crazy, dangerous, and evil. So I must say I'm really proud of the fact that I've managed to bring the country together in this way. But to put it mildly, that means that defending my position is an uphill fight. And I have to say all this actually strikes me as quite strange, because if you think about it for a moment, the really odd position that requires a defense is that we should feel an obligation to obey the Constitution. After all, the American Constitution is the oldest one currently in force in the world. It was written generations before the advent of the technological, material, cultural, and moral conditions that define modern American life. When the framers did their work, America was a small, pre-industrial society huddled along the eastern seaboard. A large portion of the country's economy was dependent on slave labor. Travel was arduous and treacherous. Communication beyond one's immediate environment took weeks or months. The framers knew nothing of nuclear weapons, mass production, multiculturalism, cell phones, professional sports, modern birth control, or global warming. They'd never heard of Martin Luther King, Bill Gates, Albert Einstein, Adolf Hitler, or Lady Gaga. It's impossible to imagine what they would have thought of women's liberation, creationism, gay marriage, psychoanalysis, reality television, globalization, war on terror. Surely the sheer oddity of making modern decisions based on an ancient and archaic text ought to give constitutionalists pause. They insist that we follow the commands of people who knew nothing of our problems and have really almost nothing to do with us. indeed who are not even biologically directly related to most of us. So we have to ask, in what sense are their hopes, fears, preoccupations, and obsessions really our own? So here's another kind of different way to make the point. Suppose for the moment that you are a member of Congress, or the President of the United States, or a Supreme Court Justice. That would make you, it would be really unique for somebody still at Mercer Law School to be any of those things, but just imagine for a moment that you were, or if you like, imagine that you're just an ordinary citizen, and you're trying to decide what to do about some important question of national policy. And let's imagine you're just very conscientious about this, so you think long and hard about the question, and you try to balance the practical and prudential concerns, but you also think about the moral questions that are implicated. You carefully consider the arguments on both sides, you consult with people who are experts, and in the end, after long and careful thought, you decide that the right thing to do is X, okay? And then you're just about to do X when somebody bursts into the room and says, wait a second, I want to tell you that 200 years ago, a bunch of people who were long dead, and who, by the way, thought that women had no role to play in public affairs, and only people with property should be allowed to vote, and that it was just fine to own other human beings. Those people, 200 years ago, wrote down that the right thing to do is not X. And then you say, oh, well, in that case, I'm just going to change my mind and do not X, just because those people said so. It seems to me, just on the face of it, the position that's really crazy is that you would change your mind and do not X for that reason. Now, some defenders of constitutional obedience attempt to meet that objection by relying on what's sometimes called the living Constitution. So, on that view, the Constitution can be brought up to date by reading its vague commands in light of contemporary realities. So, yes, the framers would be absolutely astonished to discover, say, that due process of law means the right to engage in same-sex sodomy, but precisely because the framers did not understand our world, we should read their language in modern context. At least that's what these people claim. And indeed, on that view, the very decision to formulate constitutional commands in majestically vague generalities implies a kind of decision to allow the language to change and grow over time. So that has some appeal to it, but unfortunately it's also subject to what I think are some pretty devastating objections. First, nobody claims that all of the Constitution can be made living. Some of its most pernicious provisions are as positively and absolutely dead as the Wicked Witch of the West. Unfortunately, though, unlike the Wicked Witch, dead constitutional language continues to rule us from the grave. For example, constitutional language creating the grotesquely malapportioned Senate, mandating a presidential election system that allows the loser of the popular vote to assume office, or providing no representation for congressional representation for people like me living in the District of Columbia, those provisions are not written in majestic generalities. As the constitutional scholar Sanford Levinson has argued, these provisions are hardwired. Their specificity makes them resistant to reinterpretation, and they saddle us with results that I think very few Americans would or could defend on the merits. Now, it's true that language could be changed in theory by constitutional amendment, but the amendment provisions of Article 5 are exceedingly cumbersome. These provisions are themselves hardwired. The American Constitution is the hardest constitution to amend in the world. And as a practical matter, that means the amendment process is useless when powerful minorities benefit from the status quo. Okay, well, what about more general guarantees like equal protection and due process? We can, in fact, at least sometimes escape the tyranny of the past with regard to those provisions if we interpret them in the light of contemporary realities. But as many modern originalists complain, and I have to say I think they're completely right about this, that freedom comes at the expense of authentic obligation. If due process, say, means whatever contemporaries think it ought to mean, then we're not really bound by the constitutional text in any meaningful sense. But what originalists fail to point out is that if we instead cabin or limit that provision by interpreting it according to the original public meaning or the framer's specific intent, then we're stuck with 18th century judgments about 21st century problems. Now, advocates of the living Constitution respond to this dilemma by insisting that the values expressed in those provisions are enduring even if the application of those values changes over time. But I think one might be forgiven for suspecting that the values are enduring precisely because they don't bind us to very much. It doesn't require much work, for example, to construct an argument both for and against almost any proposition based on liberty and equality. So, for example, abortion rights protect the equality and liberty of pregnant women, but abortion prohibitions protect the equality and liberty of unborn children. And to the degree that the results commanded by constitutional values are indeterminate, the obligation of constitutional obedience just doesn't take hold. You can cite the Constitution for whatever you want to cite it for. Suppose, though, that the values are at least occasionally determinate enough to settle contested cases. We still haven't solved the fundamental riddle of obedience. Either contemporary Americans share those values or they don't. If we already share the values, then we'll strive to implement them not because they are part of the Constitution, but because we share those values. If we don't share them, then we remain without an answer to the question why we should be bound by a past generation's discredited moral intuitions. Now, I know the problem's not quite that simple, and there are lots of objections that can be raised in my position. So people say, wouldn't the abandonment of the Constitution mean the end to civil liberties? What would prevent the government from establishing an official religion or jailing opponents? Wouldn't it mean complete chaos? How would we know how long the president would serve, or indeed, even if there should be a president? Now, I have responses to those objections, and I'm happy to talk about the responses during the question and answer period. Before we get to that, though, I do want to clarify one really important point. We need to be clear about what it means to obey a particular text. So my position is not that we should do much or indeed anything differently from what the Constitution commands. In many cases, the Constitution just has things right. It's just what it says makes a lot of sense. And in many other cases, it might have things wrong, but we've been doing them this way for over 200 years, and it's just not worth changing. It's important to understand that if one reaches an all things considered judgment on whatever ground that parallels the judgment contained in the Constitution, when one follows that all things considered judgment, one is not obeying the Constitution. So, for example, Orthodox Jews who don't eat pork would not be people who are obeying the Quran, right? And if New Zealand has a law against murder, when I don't commit a murder, I'm not obeying New Zealand law because I'm doing what I would do otherwise. The only circumstance in which real obedience takes hold, the only time when it does anything, is when but for the United States Constitution, one would do something else. And only because of the Constitution, you do something that you would not otherwise do. Now, in fact, there may not be all that many cases where constitutional obedience, as so understood, makes much of a difference. So, for example, freedom of speech, equal protection of the laws, and representative government, those are good things, whether or not they're in the Constitution. It might even be a good thing, I'm agnostic about it, but it might be a good thing to have an elite body like the United States Supreme Court making policy on matters that implicate fundamental values. Although I do want to insist that it would surely be better if members of that body fessed up to what they were actually doing instead of pretending they were enforcing the Constitution, and that would be something they would be forced to do if we abandoned constitutional obedience. There were other things, say a 4-year term for the president, or the exact division of power between the states and the federal government. Those may or may not be good things, but they've been around a very long time, and the controversy and risk of changing them at this point probably are not worth it. So my point is not that necessarily there'd be lots of things that would change on the ground if my thesis were adopted. So one might ask, well, what is the point? Why would the world be a better place if we gave up on obedience to the Constitution? Well, I think it would be a better place, at least in this sense. Constitutional obedience gives rise to a kind of argument that I believe is deeply destructive of the sort of mature, respectful political dialogue that we ought to be having. It means that with regard to too many questions, instead of having to engage on the merits of somebody else's argument, you're able to stop the discussion or change its direction with what amounts to an authoritarian move. In other words, I don't have to tell you why I'm wrong, why you're wrong, because even if you're right, you simply cannot do that because it's unconstitutional. And I don't think that people should be allowed to make that move. I think people have an obligation to their fellow citizens to defend their views on the merits. So I'll give you a couple of examples. First, take the healthcare debate. Now, there's a lot to be said on both sides of the merits of that debate. There are, to begin with, prudential and pragmatic questions. What's the best way to bring healthcare costs down? How can we extend coverage to people who currently don't have it? How much money should we be spending on the end-of-life care? And there are also really important questions of morality and political theory. So is it right to force somebody to buy a product that the person doesn't want to purchase? Should we choose, if people don't choose to purchase that product, should they be left untreated when they need medical care? Those are really hard and interesting questions, and there are people, intelligent people of goodwill, who come down on either side of them. So all that's really worth debating. But at least in some quarters, here's how the debate actually goes. A, I favor the Affordable Health Care Act. B, you mean Obamacare. It's unconstitutional. A, no it's not. The framers meant to allow laws just like this. B, no they didn't. They would have been horrified by a law like this. A, but what about Wickard v. Filburn? B, are you kidding? Wickard's distinguishable on 15 different grounds, right? And there you go. Now, don't get confused about this. I make my living making arguments like this, so I like to make them. It's fun, and I'd like to have a living. But I also think that way of talking about healthcare is deeply beside the point, and it prevents us from having the kind of dialogue about what is to be done that is the hallmark of a free people. Here's another example on the other side of the political spectrum. So many of my friends are surprised and horrified by this, but I happen to oppose most forms of gun control. I think in a country where millions and millions of people own guns, the effort to try to prevent them from having them is not going to work. I think a lot of it is just plain stupid. But there are certainly smart people who disagree with me about that, and I love debating about it because, as I say, most of my friends disagree with me. But here's a way not to talk about it. Instead of talking about whether gun control makes sense in 21st century America, we talk about what people in 18th century America thought about it in a world that has no resemblance to our own, talking about weapons that look nothing like ours, in a society that was rural and just completely different from ours. What I'm going to say about what those people thought is, who cares? We don't live in their world, we live in a different world. And so opponents of gun control, like me, have an obligation to make sense of the argument in our world and not in some different country, people who lived in a different time. So I hope maybe I've given you at least a little doubt about this subject. That's a beginning. I want to close by addressing another sort of counter-argument that I think is potentially the most powerful against my position. Sometimes people are ready to concede that if we were going to start over, constitutional obedience doesn't make a lot of sense. But of course, we can't start over. And the claim these people make is that the American Constitution, after 225 years, is interwoven with the country itself, with our traditions, with our self-identity. To reject the Constitution is to reject what it means to be an American. And if constitutionalism is indeed a tradition that forms the backbone of our national identity and gives meaning to our collective experience, then insisting that we give up on it is insisting on quite a lot. And I don't know that if I thought that was true that I wouldn't insist on it. But the question is, need we conceive of the Constitution in that, and constitutionalism in that way? And the argument I want to make to you, and I'm just going to sketch it here, it would take much too much time to make it in detail, but I have a piece that I'm working on now that does that. But the argument is that if you look at the great leaders and great events in our history, it turns out we have a long and honored tradition of constitutional skepticism and constitutional disobedience. Constitutional disobedience is as American as apple pie. So let me give you some examples. Let's start at the very beginning. Let's start with George Washington. In the first place, the revolution was fought against the Constitution that existed then, that is to say, British positive law. Moreover, at the Constitutional Convention itself, Washington and the other founders deliberately and blatantly disobeyed not only the charge that was given to them by Congress, but also the existing Constitution. That is to say, the Articles of Confederation. It provided that for amendment you had to have unanimous support, and the support had to be voted on by all of the state legislatures. Instead, the framers decided very early on that it was going to be approved when only 9 states voted for it, and that it would be approved by constitutional conventions rather than the legislatures. That's Washington. What about James Madison? Many people think of him as the father of the Constitution. In fact, in the Federalist Papers itself, Madison railed against what he called parchment barriers and argued that constitutional text could limit government only if men were angels. And he insisted men were not angels. What about Thomas Jefferson? Here's something you don't learn in high school about Thomas Jefferson. He was a lifelong skeptic of the Constitution. He insisted many times over the course of his career that the earth belonged to the living. And he analogized constitutional obedience to of one generation ruling over another to one country ruling over another. And he said that kind of intergenerational imperialism was fundamentally wrong. Moreover, this was not just a theoretical position for him. By his own lights, he committed what was probably the most important constitutional violation in the history of the country. So Jefferson himself believed that acquiring the Louisiana Purchase was unconstitutional. And at first, he proposed constitutional amendments to deal with it, but then it turned out the French and the Spanish were about to back out. So he decided, and he said this, he was perfectly candid about this, after his term ended, he decided to hell with the Constitution. This is really important for the country, and I'm going to do it whether the Constitution allows it or not. And you can imagine how different the country would look today had he made a different decision. Now, many people thought that then and now that Jefferson was overly scrupulous in his view that the Constitution prohibited acquiring the Louisiana Territory, but few would disagree with Jefferson's own judgment about a less consequential matter. He spent money that was not appropriated by Congress in the so-called Chesapeake affair, where there was war, a threat of immediate war, and he didn't think our ships were in shape to deal with it, so he just, and Congress hadn't appropriated the money, he just went ahead and spent it anyway. And he said, again, after he was no longer president, he thought that was the right decision because it was for the good of the country. Obviously, the Southern secession during the Civil War was a massive constitutional violation, but what's less often remembered, and in some ways more important, is that the leading abolitionists, people who we greatly admire today, like William Lloyd Garrison, Frederick Douglass, Wendell Phillips, all those people were constitutional skeptics. Garrison publicly burned the Constitution. And he said that many times, he said the Constitution was a pact with the devil. Both Frederick Douglass and Wendell Phillips argued for northern secession from the South in violation of the Constitution. What about Abraham Lincoln? Well, he's a really interesting and complicated case, and I can't get to the bottom of it here. He usually presented himself as a defender of the Constitution, and indeed in his first inaugural, he said he expressed no interest at all in the abolition of slavery. He said it was beyond the power of the federal government, and his only interest was in enforcing the Constitution. Nonetheless, there's no doubt that, or little doubt, that in the crisis of 1861, he violated the Constitution when he unilaterally suspended habeas corpus, and again spent money that wasn't appropriated by Congress. When the Chief Justice of the United States ordered him to free a prisoner who'd been arrested without trial, he just ignored the order. When a federal judge ordered the release of another person, of somebody from the Army, the general in charge arrested the person who delivered the writ. And to make matters worse, Secretary of State Seward ordered that the judge's salary be withheld. What's much more interesting, though, and I think more consequential, is the Emancipation Proclamation, one of the great acts of American history. Now, Lincoln, like most of his contemporaries, insisted over and over again that the Constitution did not permit the federal government to abolish slavery where it already existed. And indeed, in private correspondence, he said that he could not see how the abolition of slavery could be justified as a war measure, especially when it was permanent, when it would take, if it would take effect even after the war was over. Nonetheless, Lincoln issued both the preliminary Emancipation Proclamation and the permanent one, and he made very clear that the freedom of the slaves was to be permanent. He rejected the advice of some people who said that he ought to end the war if, in exchange, if the South agreed to end the war, he would agree to the re-enslavement of African Americans. He said, absolutely not. And By the end of the war, he had, and I think most of his contemporaries understood, and he certainly understood, that the nature of our war aims had changed. It was no longer to enforce the Constitution that we were fighting, it was instead to abolish slavery. So the preservation of the Union was going to be the birth of a new freedom. And it's just a fact that when the slaves ultimately were freed, that was not through constitutional processes. The Constitution, since the founding, had been the principal obstacle to the freeing of the slaves. When the slaves were freed, it was because there was an armed conflict in which 750,000 people died, and in which the leaders of our country were ready to ignore the Constitution. That's how it happened. Okay, there's more. I won't go on much longer, but Woodrow Wilson, as a young academic, wrote an important book that criticized the Constitution and said it was unworkable. In the 1912 presidential campaign, Wilson argued that the Constitution ought to be amended much more easily so as to overrule what he viewed as pernicious decisions, but he was the moderate in that campaign. The person who attacked the American Constitution consistently and vehemently was Theodore Roosevelt. That is, his radicalism on that subject is a large reason why he did not get the Republican nomination in that year. And he went throughout the country in 1912 as the Bull Moose candidate, arguing that the Constitution was archaic, that it was standing in the way of progress, that Supreme Court decisions ought to be overruled by popular referendum, and that we needed a constitutional revolution in this country. Franklin Roosevelt asserted repeatedly that he was not going to be bound by Supreme Court decisions he didn't like. In the 1943, I think, or 42, when German saboteurs were found on United States territory, he told his Secretary of State, his Attorney General, Francis Biddle, that the men were to be tried by a military commission, and that if somebody tried to serve a writ of habeas corpus on him, it should simply not be accepted. In his great 1937 Constitution Day speech on Constitution Day, he told a huge throng gathered at the Washington Monument that the Constitution was not a legal document at all, that it was simply a statement of high-minded ideals, and that political leaders should be free to interpret those ideals in order to meet modern needs in a way that was not constrained by what lawyers thought. There are many other examples I could cite, but I think that's enough to make the point. The fact is that we are not inevitably and ineluctably bound to a text written 200 years ago. Ultimately, the framers do not have any power over us. And to give up our own power to them is, ironically enough, to violate the first three words of the Constitution itself. The Constitution starts by talking about we, the living people, not they, the dead people. And the ultimate argument for constitutional disobedience is that this is our country. It belongs to us. We wouldn't put up for a minute to have, let us say, the French government or the Russian government tell us how to run, or the United Nations to tell us how to run our country. And we shouldn't put up for a minute to have what Jefferson referred to as another country, that is, people dead 225 years ago, to have them tell us how to run our country either. We live here. This country belongs to us. We have a right to decide for ourselves what kind of a country we want to have. And as soon as we get over the idea that that's been decided for us and that we have no agency as soon as we get over that idea, we will become the truly free country that we like to think we are. Okay, now I'm sure everybody's absolutely convinced by that, so there are no questions for Jeff.